afternoon. Welcome to today's sessions with Sarah. So for those of you who don't know me or haven't joined in these chats before, I am Sarah Coombs. I am a solicitor here at TBA Law, working primarily in family law, but also property as well. In each of these sessions, we're trying to deal with an issue that someone has asked us about recently, but we also do accept submissions. So if you would like us to discuss something specific next month, please send us an email or comment on the video and we can discuss it. Today's topic is grandparents and family law, which is actually a topic that tends to get a lot of reaction when we do talk about it, because a lot of people don't consider the implications of a relationship breakdown for other people, particularly grandparents, and it's one that grandparents tend to get affected quite a lot, purely because obviously when times change for parents with their kids, there's an onflow to other relatives, and this information isn't just relative for in relation to grandparents per se, but it also relates to other family members. So it's really important to have an understanding of what the law is surrounding this, what can be done, and what your rights are. So to start off with, we see this quite commonly in situations where a parent's relationships break down, the children spend time according to the agreement between the parents, and then there may not be enough time for grandparents to see the children. This particularly occurs when the parents of the children no longer speak to their parents as well, which makes it increasingly difficult because they've got no path to get access to the kids. When it is possible, we do recommend that grandparents spend time with their grandchildren via their parents. It keeps things simpler, neater, and obviously the whole family unit gets to spend some time together. But what are your rights if this isn't possible? So the Family Law Act, which is the primary bit of legislation that governs the whole family law area, deals not only with parents and their rights, but any person who may have a meaningful connection to the child's life or is an important figure in their life. And so that's the category that grandparents or aunts and uncles, cousins, brothers, sisters, potentially even fall into. So therefore, every right that a parent has under the Family Law Act, so too does a grandparent. Some of those aren't inherent. So for example, under the Family Law Act, both parents of a child have the presumption of equal shared parental responsibility, meaning that they have the power to make the decisions and the right to make the decisions for the child's everyday care and welfare, and the long-term decisions for their life as well, like where they go to school, religion, healthcare and the like. Grandparents don't have that right automatically, but they do have the right to apply for that right if necessary. So therefore, if you're not getting to spend time with your grandchildren, you do have the right under the Act to apply for time with the children, or in extreme circumstances even apply to become potentially their primary carer. So therefore your rights are protected under the Act, but it doesn't mean that it's an easy process, and therefore that's why we recommend if you can spend time with your grandchildren through the parents, that is preferable. It's also important to note that a court will always give preference to a child having a relationship with a parent over a grandparent. So even though those rights are enshrined in the Family Law Act, it doesn't mean that your rights are equal to those of your child who is the child's parent. So the basic question is, what can I do if I want to spend time with my grandchildren and I'm not at the moment? So the first step we always recommend, and because it's the same process as for parents, is to do what's called family dispute resolution. So this is a form of mediation that is facilitated most likely by Relationships Australia, but there are different bodies who do it. And so this is a form of mediation where the parties go, there are no legal representation and no binding orders or decisions are made, that facilitates a discussion between two parties, whether it be the grandparents and both the parents, the grandparents and one parent, whatever the situation may be, to have a discussion to try and negotiate amicably and without the need for court intervention for the parties to have some time with the child. These sessions are fantastic because they are minimal cost, so it's about $80 I think off the top of my head to go to one. They can take a while to get into, so they're 2 to 3 months to get into them, but that's nothing on the court process. They leave relationships in better tact than going through the court process. They're obviously a huge amount cheaper than going through the court process. And coming out of it, you can come out with what's called a parenting plan. This isn't a binding document. What this document is it essentially sets out the time arrangements for the children. The parties sign it, so it's not legally binding, but it is acknowledged by the court as a document that the parties signed. In worst case scenarios, obviously going to family dispute resolution is not enough. In those circumstances, court action may be necessary to be done. Obviously it is a last resort, and the limitations on that are quite severe in that for grandparents in particular, the court will always prioritise time with the parents over time with grandparents. Obviously this is case dependent and I am generalising to some degree. The time it takes, so from initial application through to final trial, it can be a year, it can be 2 years, it can be 3 years, it can be a very long time, in which time children grow up, and there's all those sort of issues involved there as well. And the cost involved as well can be fairly significant for both parties. And the reality of having a good relationship with the parent of the child after these court proceedings is pretty minimal, although having said that, it can be done. So the court process works something along the same lines as a parenting court, for when both parents are involved in the court process. So it starts with an application filed by one of the parties. In these circumstances, you would suspect it would be the grandparents because the child would already be with the parents. From there, it goes to an initial mention before the court, where the court assesses what is needed. From there, it goes down to the court will often order what's called a family report or a Section 11F. Section 11F is a shorter, more concise document. A family report is a more full-bodied assessment of the situation, but what both these reports aim to do is determine what is in the best interests of the child. And by doing this, the court normally has the parents, the grandparents, any parties to the proceedings, and the children attend upon what's called a family consultant, who then analyses the relationship between the parties and makes recommendations. They'll take into consideration primarily what is the best interest of the child, so what both parties are expressing, what time they want with the child, what they think the child can handle, and if the child is old enough, also what the child would like to do. In these circumstances, if the child is non-verbal, the court won't give a lot of heedance to that, or if the child is under maybe 5 years old, they won't give a lot of thought, consideration to what the child wants. But the older the child becomes, the more say they have in where they live and what they do. So if they don't want to spend time with the grandparents, that's going to weigh heavily against grandparents. Equally, if they do want to spend time with their grandparents, that is going to be considered quite weighty. Once those reports are done, it will be set down for final trial potentially. They may refer it to mediation. There are a few different processes that can be done in this situation. And from there it goes to final trial, which can run for up to 3 or 4 days. Again, the cost of it is quite extensive, and I do recommend that anyone considering legal proceedings, if they are grandparents, seek legal advice. It is a complex area of the law, and if it can be resolved outside of the court, it is definitely preferable. But the important takeaways from today are to recognise that grandparents do have the same rights as parents in terms of having a meaningful relationship with the child. That the child's best interests will always be considered paramount. So if a court deems it inappropriate for a child to have contact with the grandparent or unnecessary, they may not order it. That you do have the same rights in terms of bringing an application or seeking a resolution, i.e. going to court or through family dispute resolution. So those options are open to grandparents as well as parents. And the process is a relatively complex one, so it is worth getting the legal advice before you commence to make sure everything is covered. I believe that covers just about everything that needs to be covered today on grandparents and family law. We do have a blog on our website covering this topic as well, which I would highly recommend people go and read if they want some more information about this topic. People are also welcome to email or submit a question at the bottom of this video, and we will endeavour to respond. And that sums up our sessions with Sarah for the week. I do take recommendations, so for July, if anyone would like a particular topic discussed, please let us know and we would be happy to cover it. So thank you all very much. Have a good day, and any questions, let our office know.